Hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today let us learn a new topic in the public international law. We have continental shelf and the high seas. In the first slide there is a picture for a quick note of the maritime zone where you have a different demarcations representing the territorial sea, exclusive economic zone, contiguous zone, continental shelf, high sea. All these are given in a picture note. Legal status of continental shelf and high seas. The law of the sea is that law by which states, coastal and landlocked, and or international organizations regulate in respect of those areas subject to coastal state jurisdiction and in relation to those areas of the sea and the seabed beyond national jurisdiction. The rules governing the sea are drawn from both custom and the treaty. The development of marine science and technology compelled the international community to protect the conventional sea uses. Consequently, Geneva Conventions on the Law of the Sea were adopted by the 1958 Conference. The need to preserve the seas as the common heritage of all mankind and the danger of a scramble for the seas resulted in the 1982 Convention on the Law of the Sea. The 1982 Convention was adopted on 30th April 1982 and has signed by some 157 states but not by countries such as Germany, UK and USA. In the previous videos, we have studied about the territorial jurisdiction over the land, and now we are studying the jurisdiction and the legal status in the sea area. So, what is the legal status of the continental shelf and the high seas, which are little deeper than the regular contiguous zone, territorial zone and the little of exclusive economic zone? So, how much is the state's authority over the continental shelf and high seas? Let us get into deep. Continental shelf. Continental shelf is the geographical term used to describe the gently sloping ledge covered by shallow water protecting from the shoreline of many land masses before a steep descent into the ocean waters. The continental shelf of a coastal state comprises the seabed and the subsoil of the submarine areas extended up to the outer edge of the continental margin. The continental margin consists of continental shelf slope and the rise that separates the landmass from the deep ocean floor, that is abscissal plain. From the first slide of the picture, we can see how is the continental shelf getting demarked. The continental shelf consists of the steep descent to the ocean waters. It comprises the seabed, subsoil of the submarine areas up to the outer edge of the continental margin. So, in this continental margin, we have continental shelf slope that separates the landmass from the deep ocean floor. This is the continental shelf which is from the outer edge. Article 76 of the 1982 Convention defines continental shelf as the seabed, the subsoil of the submarine areas that extend beyond its territorial sea throughout the natural prolongation of its land territory to the outer edge of the continental margin at a distance of 200 nautical miles from the baselines from which the breadth of the territorial sea is measured, where the outer edge of the continental margin doesn't extend up to that distance. So, from the first slide, there is a picture of maritime zone where we can understand the green part of the continental shelf, which is where there is a steep slope and the landmass continues up to the outer edge. From the baseline to the outer edge, nearly up to 200 nautical miles from the baseline is nothing but the continental shelf. The continental shelf extends to 200 nautical miles for all the states but retains an advantage for the geographically favored states. In this article, we have two clauses. Article 76 clause 6 provides the continental shelf shall not exceed 350 nautical miles from the territorial baselines, and Article 76 Clause 7 provides the method to be employed where the continental shelf exceeds 200 nautical miles. So, in this convention, 1982 convention, in the Article 76, it provides that it cannot extend beyond 350 nautical miles, and in Clause 7, it provides the method to be employed where continental shelf exceeds 200 nautical miles. According to 1982 convention, a coastal state's rights are exclusive regarding natural resources in the continental shelf. So, the state has the right to its natural resources in the continental shelf. Natural resources are defined as the mineral and other non-living resources of the seabed and the subsoil together with living organism in the shelf of a coastal state. Exploration and exploitation activities may not be undertaken without the consent of that state. So, the state has complete authority. The state has complete authority over that continental shelf to do exploitation, exploration, and to find all the natural resources of its in that particular area of that state. A coastal state's rights are not territorial sovereign rights but are functional rights for the purpose of exploring and exploiting the natural resources of the continental shelf. A coastal state has exclusive right to authorize and regulate relying on the continental shelf for all the purposes. So, it is only the state's authority over the continental shelf, whether the natural resources are found for exploitation or exploration, anything, the state has its own authority, and it is not the territorial sovereign rights, but it is the functional rights for purpose of exploiting and exploring the natural resources. A coastal state's rights in the continental shelf do not affect the status of the superjacent waters as the high seas or that airspace above those waters. The states in exercising their rights on the continental shelf must not impede the laying or maintenance of submarine cables or pipelines. So, the state has authority to function all the rights like exploring, exploiting the natural resources, and it should not affect or it should not do it by wanted further undertaking the maintenance of submarine cables or pipelines. So, it should not affect any kind of superjacent waters in the high seas in that and anything which is above the airspace of those waters. So, this is the legal status of the continental shelf with respect to that state's authority. High seas. The high seas have been described as the coherent body of water over the greater part of the globe that lies outside the territorial waters, the straits, the Gulf bays, the archipelagic waters and exclusive economic zones. According to Article 86 of the 1982 Convention, waters are not included in the exclusive economic zone, the archipelagic waters of the archipelagic state, the territorial waters or internal waters of the state constitutes the high seas. In this, in the picture, in the first slide, we can see that high seas are far away from the exclusive economic zone, contiguous zone, territorial sea, continental shelf. So, the part which is away, more than away, which are called high seas, which excludes all these territorial waters, straits, Gulf bays, archipelagic waters and exclusive economic zones. This part is nothing but the high seas. With a view to consolidate the law of the sea, the United Nations Conference on the Law of the Sea adopted in 1958 a convention on the high seas. This convention was further amplified by the Convention on the Law of the Seas in 1982. The 1982 convention provides certain freedom of high seas. What are those freedoms? Freedom of high seas are nothing but the high seas are open to all states, whether coastal or landlocked. The freedom of high seas is under the conditions laid down by 1982 and by other rules of international law. The 1982 convention provides for particular freedoms for these high seas. So, as these high seas are beyond the control over a state, so these high seas have certain freedom for all the states to be. It is not exclusive. It is it is controlled by all other states which are whether coastal or landlocked. So these particular freedoms, that is freedom of navigation, freedom of overflight, freedom to lay submarine cables and pipelines, freedom of fishing, freedom to construct artificial islands and other installations, and freedom of scientific research are some of the freedom of high seas. And these are not exclusive but are open to all states. Regarding freedom of navigation, every ship sailing in the high seas must fly its flag of its states. State shall fix the conditions for the registration of ships and grant of its nationality and grant of flag documents to the ships. A ship which sails under no flags may not claim any nationality in question, as the ship without nationality may not get any immunity or protection. So whichever ship is traveling in that high sea should raise a flag, should raise a flag of its nation, and then only it can have any kind of immunity or protection in that high sea area. Without a ship which sails without any flag of that nationality has no question of immunity or protection. The ships in the service of the United Nations or its specialized agencies shall however fly the flag of their organization. Every state must exercise administrative, technical and social control over ships flying its flag. Every state shall prevent and punish the transport of the slaves in ships authorized to fly its flag. So in this, these ships should carry their own national flag, and then only they have immunity or protection, and they should not do any illegal activities within the ships even though they are carrying their national flag. So any kind of illegal activities will be punished or penalized, or that property or that particular ship will be seized. The 1982 Convention requires states to cooperate in the suppression of illicit traffic in narcotic drugs and psychotropic substances engaged in by ships or on the high seas contrary to international conventions. All states shall cooperate in the repression of piracy on the high seas. Every state has right to seize a pirate ship and arrest the persons and seize the property on board. So any kind of illegal activity like drug trafficking or illicit transportation of psychotropic substances or transporting the slaves or any kind of illegal or illicit activity will be punished and penalized, and that property and the persons will be taken under control. So this is one of the freedom. This is one of the freedom of what you call is freedom of high seas in regarding to the navigation. Next is right of hot pursuit. The warships, the law enforcement vessels of the coastal state may pursue a vessel leaving its territorial waters when it suspects it of having violated its laws and regulations. The right of hot pursuit ceases as soon as the ship pursued enters the territorial sea of its own state or a third state. In this right of hot pursuit, what it says is any kind of warships or which are law enforcement vessels of the coastal state leaving its territorial waters when if it suspects it is having any has violated its law or it has violated any kind of regulation, the right of hot pursuit is no more valid. It gets seizes as soon as the ship enters into the territorial waters of its own land or into another state. Right to lay submarine cables and pipelines. All states are entitled to lay submarine cables and pipelines on the bed of the high seas. Breaking or injury to the submarine cables and pipelines beneath high seas by its own ships or persons on board done willfully or by negligence shall be a punishable offence. So, because the high seas have such kind of freedom to lay down the cables and pipelines, if any person, if by default or by any kind of deliberation they have any negligence in damaging the pipelines or cables, will be a punishable offence. Next is fishing activities on the high seas. All states have the right for their nationals to engage in fishing on the high seas, subject to their treaty obligations. All the states have the duty to conserve the living resources of the high seas. Even if they want to do fishing in the high seas also, when particular if there is any kind of bilateral treaty to do fishing or any kind of a multilateral treaty to do fishing, then the states have authority to do it in the high sea areas. Protection to marine environment. Article 192 of the 1982 Convention envisages that states are under the general obligation to protect and preserve the marine environment. States are required to adopt laws and regulations with regard to pollution from land-based sources, seabed activities, dumping and pollution through the atmosphere. So, we have got all freedom in the high sea areas, and all that is not exclusive, and any state can participate in this using these freedoms is not just to use as it is, but if we have to respect the nature and we have to protect the marine environment. Any kind of pollution activities or sea dumping activities are taking place, then that will be punished according to conventions of 1982. So, protection of the marine environment is also an important factor involving the freedom in the high seas.